There is a difference between proven evidence and credible allegations. Viva Frei, Montreal litigator turned YouTuber, and I think in 20 years' time we are all going to remember the 2020 elections. But as of today, November 10, 2020, the only thing people are really talking about is the US presidential elections and the fact that who's texting? Let me see who this is. It's about the elections, and the fact that the outcome is so hotly contested. On the one hand, you have roughly half of America saying something smells a little fishy here, and on the other hand, you have the other half of America with the support of the mainstream media saying nothing to see here, everything was good, let's transition into a Biden presidency. On the one hand, you have the mainstream media saying there is no evidence of any fraud. On the other hand, you have the mainstream media saying there is no evidence of any widespread fraud. On the other hand, you have the mainstream media saying where they find glitches, they have reversed them. It is something of a moving target, but the underlying sentiment and the underlying mantra of the mainstream media is that there is no evidence of fraud. What the mainstream media either deliberately or inadvertently fails to recognize is that to come to the conclusion that there is no evidence of election fraud is to come to a judicial determination at the stage of the allegations themselves. At this point in time, in my humble opinion, it is entirely premature to come to the conclusion that there is no evidence of any voter irregularities. At this point in time, all anybody needs to be asking themselves is, are the allegations credible? Are the allegations sufficiently serious that a further investigation or trial is required? And I've got to tell you, after reading the Michigan lawsuit, I don't think anybody can credibly say that the accusations and the allegations are not themselves credible. So in this vlog, we are going to walk through the Michigan election lawsuit, and you're going to come to your own conclusion as to whether or not the prima facie evidence alleged in that lawsuit is sufficiently serious to warrant, at the very least, further investigation. State of Michigan, in the Circuit Court for the County of Wayne. Cheryl A. Constantino and Edward P. McCall Jr., plaintiff, versus City of Detroit and others. Complaint and application for special leave to file quo warranto complaint. What is a quo warranto complaint, you might be asking yourself? Good question. Quo warranto is used to test a person's legal right to hold an office, not to evaluate the person's performance in the office. For example, a quo warranto action may be brought to determine whether a public official satisfies a requirement that he or she resides in the district, or whether a public official is serving in two incompatible offices, or if they were improperly elected in the first place through a tainted election process. Now, it is a long lawsuit, and we're not going to go through the entire thing. I'm just going to draw your attention to what I feel to be the highlights in order to understand the essence and basis of the lawsuit. But just before we do that, a foreword. Allegations in a lawsuit are just that. They are allegations. They are not yet proven fact. In fact, nothing is a proven fact in a court of law until a judge accepts it as fact, and that is what is called making evidence.
Well, that's a very entertaining story, but unfortunately, real detectives have to worry about that little thing called evidence.
A document, a picture, testimony is not evidence until a judge accepts it as evidence, and a fact is not a fact until a judge says, based on the evidence, this is what I deem to be a legal fact. When it comes to the affidavits filed in support of this lawsuit, those affidavits themselves are nothing but sworn statements. And when I refer to the affidavits as nothing but sworn statements, that is to say that they are sworn statements made under oath, typically under penalty of perjury, but they are not yet evidence. A judge can either accept or dismiss portions or the entirety of the affidavits after the affiants have been examined and cross-examined in front of the judge. All that to say, the affidavits may contain serious allegations, but they nonetheless need to be proven in front of a judge. So with that said, let's see what is alleged in the Michigan lawsuit as far as voter irregularities are concerned. In summary, this complaint raises numerous instances of fraud, including but not limited to: A. Defendants systematically processed and counted ballots from voters whose names failed to appear in either the qualified voter file or in the supplemental sheets. When a voter's name could not be found, the election worker assigned the ballot to a random name already in the QVF to a person who had not voted. B. Defendants instructed election workers to not verify signatures on absentee ballots, to backdate absentee ballots, and to process such ballots regardless of their validity. C. After election officials announced the last absentee ballots had been received, another batch of unsecured and unsealed ballots without envelopes arrived in trays at the TCF Center. There were tens of thousands of these absentee ballots, and apparently every ballot was counted and attributed only to Democratic candidates. D. Defendants instructed election workers to process ballots that appeared after the election deadline and to falsely report that those ballots had been received prior to November 3, 2020 deadline. E. Defendants systematically used false information to process ballots, such as using incorrect or false birthdays. Many times, the election workers inserted new names into the QVF after the election and recorded these new voters as having a birth date of 1/1/1900. F. On a daily basis leading up to the election, City of Detroit election workers and employees coached voters to vote for Joe Biden and the Democratic Party. These election workers and employees employees went over to the voting booths with voters in order to watch them vote and coach them for whom to vote. G. Unsecured ballots arrived at the TCF Center loading garage, not in sealed ballot boxes, without any chain of custody and without envelopes. H. Defendant election officials and workers refused to record challenges to their process and removed challengers from the site if they politely voiced a challenge. I. After poll challengers started discovering the fraud taking place at the TCF Center, defendant election officials and workers locked credentialed challengers out of the counting room so they could not observe the process, during which time tens of thousands of ballots were processed. And J. Defendant election officials and workers allowed ballots to be duplicated by hand without allowing poll challengers to check if the duplication was accurate. In fact, election officials and workers repeatedly obstructed poll challengers from observing. Defendants permitted thousands of ballots to be filled out by hand and duplicated on site without oversight from poll challengers. Alright, so that might have been a little lengthy, but that is the essence of the allegations that would be found throughout the lawsuit, detailed in greater detail in the lawsuit. The most amazing thing to appreciate is that all of these allegations are supported by 7 sworn affidavits with first-hand knowledge of that which they include in their affidavits. There may be, and in fact is, some hearsay in their sworn affidavits, but at the very least in their sworn affidavits is first-hand knowledge of what they were told and what they in fact did. And just one point of clarification on the topic of hearsay. As relates to my vlog of yesterday, there was some discussion as to what hearsay is. Incidentally, if you haven't seen that vlog, I'm going to link it right here. Give it a watch. It's a good one. I go through the Project Veritas USPS whistleblower affidavit. In that USPS employee's affidavit, he had sworn to the fact that he had heard his boss say to somebody else to backdate mail that they had received so that it looked like it came in on November 3rd, and I qualified that as hearsay. A lot of people in the comment section were rightly pointing out that that did not fit their understanding of the concept of hearsay. Hearsay is I heard from someone else that someone else told them that. That is not the legal definition of hearsay. Hearsay, the legal definition, really is just relaying in court a statement made out of court as proof of the truth of that statement. So in theory, when the affiant says, I heard Mr. X say to Mr. Y something was going to happen, when he relays that statement in court, that is hearsay because he is trying to bring into court a statement made out of court to prove the truthfulness of that statement, hence hearsay. It's not always inadmissible, it might just lack probative value, and there are exceptions to hearsay which are statements made against the interest of the accused, but even that is still nonetheless technically hearsay. It's just an exception to the rule of the inadmissibility of hearsay. Okay, parentheses closed, let's move on. Forging ballots on the qualified voter list. An attorney and former Michigan Assistant Attorney General was a certified poll challenger at the TCF Center, Exhibit A, affidavit of Zachary Larson.
Hey, thanks a lot, Mr. Larson.
As Mr. Larson watched the process, he was concerned that ballots were being processed without confirmation that the voter was an eligible voter in the poll book because of information he had received from other poll challengers. That may be hearsay. Mr. Larson heard from somebody else that there was a problem, but then we get into Mr. Larson's first-hand knowledge. Mr. Larson reviewed the running list of scanned-in ballots in the computer system, where it appeared that the voter had already been counted as having voted. An official operating the computer then appeared to assign this ballot to a different voter as he observed a completely different name that was added to the list of voters at the bottom of a running tab of processed ballots on the right side of the screen. Exhibit A. Exhibit A is Mr. Larson's sworn affidavit. Mr. Larson was concerned that this practice of assigning names and numbers indicated that a ballot was being counted for a non-eligible voter who was not in either the poll book or the supplemental poll book. From his observations of the computer screen, the voters were not in the official poll book. Moreover, this appeared to be the case for the majority of the voters whose ballots he personally observed being scanned. The lawsuit goes on to allege that after Mr. Larson brought these anomalies to the attention of the appropriate people at the polling station, an incident ensued and he was basically deprived access or appropriate viewing under a number of bases, ultimately COVID, and ultimately just left the room altogether. After Mr. Larson observed and uncovered the fraud that was taking place and had the confrontation with the supervisor, he left the counting room to consult with another attorney about the matter around 1:30 p.m. to 2 p.m. It was at this point that election officials stopped permitting any further poll challengers to enter the counting room, including Mr. Larson. Election officials never allowed Mr. Larson to re-enter the counting room to fulfill his duties as a poll challenger after he had discovered the fraud which was taking place. So that is the story from Mr. Larson, but there is a lot more included in this lawsuit. Illegal voter coaching and identification issues. An election employee with the City of Detroit was working at a polling location for approximately 3 weeks prior to the election. The City of Detroit employee directly observed on a daily basis other City of Detroit election workers and employees coaching voters to vote for Joe Biden and the Democrat Party. The employee witnessed these workers and employees encouraging voters to do a straight Democrat ballot and witnessed these election workers and employees going over to the voting booths with voters in order to watch them vote and coach them for whom to vote. Exhibit B, affidavit of Jesse Jacob. Alright, so that is one accusation. Some people may think it's less serious than others, that the employees were telling people who to vote for or coaching them to vote for Joe Biden, whatever. But it gets even more serious. All absentee ballots that existed were required to be inputted into the QVF, that is the Qualified Voter File system, by 9 p.m. on November 3, 2020. This was required to be done in order to have a final list of absentee voters who returned their ballots prior to 8 p.m. on November 3, 2020. In order to have enough time to process the absentee ballots, all polling locations were instructed to collect the absentee ballots from the drop box once every hour on November 3, 2020. On November 4, 2020, a City of Detroit election worker was instructed to improperly predate the absentee ballots received date that were not in the QVF as if they had been received on or before November 3, 2020. She was told to alter the information in the QVF to falsely show that the absentee ballots had been received in time to be valid. She estimates that this was done to thousands of ballots. Exhibit B. And bear in mind that Exhibit B is a sworn affidavit from the employee of the city, an employee who had been working for the City of Detroit for decades. That is not to say that it is infallible, proven fact. That is only to say that someone with a lot to lose is saying something under penalty of perjury, and it is a very serious allegation of first-hand knowledge. Illegal double voting. The election employee observed a large number of people who came to the satellite location to vote in person, but they had already applied for an absentee ballot. These people were allowed to vote in person and were not required to return the mailed absentee ballot or sign an affidavit that the voter lost the mailed absentee ballot. Exhibit B. This would permit a person to vote in person and also send in his/her absentee ballot. Prior to the election, the Michigan Secretary of State sent ballot applications to deceased residents and to non-residents of the state of Michigan. Appreciate here that there is no actual allegation of outright fraud, but rather only the possibility that people who came in to vote the day of were not asked to confirm that they had lost their mailed ballot, so that in theory it's possible that they voted in person and nonetheless sent in their mailed ballot as well. So the allegations do go from first-hand knowledge to possibilities or conjecture, but all that to say, it is nothing that can't be resolved with an audit to double-check that everyone who voted in person did not also send in their mailed-in ballot. Transparency that might be totally necessary to ensure that people view the process of having the slightest bit of legitimacy. That being said, we soon get into some very, very serious allegations. First round of new ballots. At approximately 4 a.m. on November 4, 2020, tens of thousands of ballots were suddenly brought into the counting room through the back door. Exhibit C, affidavit of Andrew Sito. These new ballots were brought to the TCF Center by vehicles with out-of-state license plates. It was observed that all of these new ballots were cast for Joe Biden. Exhibit C. It is entirely possible that this affiant is a pathological liar. It is entirely possible that they are fabricating the entire story. It's entirely possible that they totally misunderstood what they saw with their own two eyes. It is also entirely possible that these allegations are sufficiently serious that an investigation is warranted and a trial should be held. And if the first round of new ballots wasn't enough, there was also a second round of new ballots, allegedly. Second round of new ballots. The ballot counters were required to check every ballot to confirm that the name on the ballot matched the name on the electronic poll list. This was the list of all persons who had registered to vote on or before November 1, 2020, and is often referred to as the QVF. Exhibit D, affidavit of Bob Cushman. The ballot counters were also provided with supplemental sheets which had the names of all persons who had registered to vote on November 2, 2020 or November 3, 2020. The validation process for a ballot requires the name on the ballot to be matched with a registered voter on either the QVF or the supplemental sheets. At approximately 9 p.m. on Wednesday, November 4, 2020, numerous boxes of ballots were brought to TCF. Exhibit D, the affidavit. Upon information and belief, the Wayne County Clerk's Office instructed the ballot counters to use the date of birth of January 1, 1900 on all of these newly appearing ballots. And for your own personal knowledge, whenever you see on information and belief, that refers to knowledge that is not first-hand knowledge, so take it for what it's worth. None of the names on these new ballots corresponded with any registered voter on the QVF or the supplemental sheets. Despite election rules that required that all absentee ballots be inputted into the QVF system before 9 p.m. on November 3, 2020, the election workers inputted all of these new ballots into the QVF and manually added each voter to the list after 9 p.m. Exhibit D. Upon information and belief, the vast majority of these new ballots indicated the voter's date of birth as January 1, 1900 entered into the QVF. These newly received ballots were either fraudulent or apparently cast by persons who were not registered to vote prior to the polls closing at 8 8 p.m. on November 3, 2020. The lawsuit then goes on to allege further restricting of access of the challengers to view the counting process, but then it goes on to make some more allegations of substantive fraud. Absentee ballot signatures. Whenever a person requested an absentee ballot either by mail or in person, that person was required to sign the absentee voter application. When the voter returned his/her absentee ballot to be counted, the voter was required to sign the outside of the envelope that contained the ballot. Election officials who processed absentee ballots are required to compare the signature on the absentee ballot application with the signature on the absentee ballot envelope. Election officials at the TCF Center instructed workers to never validate or compare the signatures on absentee applications and the absentee envelopes to ensure their authenticity and validity. Exhibit B. The factual allegations of the lawsuit conclude by talking about unsecured ballots, how challengers saw tens of thousands of ballots arriving in unsecured boxes, open boxes, contrary to the law. And with all those allegations of fact out of the way, we get to the charges in law, the counts 1 through however many, starting with count 1. Count 1, constitutional right to accuracy and integrity of elections. Michigan Constitution, Article 2, Section 4, Paragraph 1H. Based upon all the allegations of fraud, statutory violations, and other misconduct as stated herein and in the attached affidavits, it is necessary to enjoin the certification of the election results pending a full investigation and court hearing, and to order an independent audit of the November 3, 2020 election to ensure the accuracy and integrity of the election. Now, who can disagree with that? If publicly traded companies have to produce annual audited financial statements, I think the election process, when required, can produce an audited result of the election process so that people believe it was legitimate. Now, I know a ton of you are going to say that no matter what happens, no matter what is done, half the population is never going to believe that this election process was legitimate. Well, I'll tell you what, when you audit the results, you certainly take away one argument from them. Now, on to count 2. Count 2, statutory quo warranto claim. Election fraud. MCL 600.45452 permits an action to request the issuance of a writ of quo warranto if the action is brought within 30 days after the election upon the request of, quote, any citizen of the county by special leave of the court or a judge thereof. The statute also requires this action to, quote, be brought against the municipality wherein such fraud or error is alleged to have been committed, end quote. Quo warranto may be brought to remedy fraudulent or illegal voting or tampering with ballots or ballot boxes before a recount pursuant to MCL 168.861, which states, for fraudulent or illegal voting or tampering with the ballots or ballot boxes before a recount by the Board of County Canvassers, the remedy by quo warranto shall remain in full force together with any other remedies now existing. Based upon the allegations contained herein, material fraud or error occurred in this election so that the outcome of the election was affected. Based upon the above allegations of fraud, statutory violations, and other misconduct, as stated herein and in the attached affidavits, it is necessary to issue a writ of quo warranto and order appropriate relief, including but not limited to enjoining the certification of the election results pending a full investigation and court hearing, ordering a recount of the election results, or voiding the election and ordering a new election to remedy the fraud. And then we have count 3, common law quo warranto claim, election fraud, pretty much the same conclusion being sought. Count 4, equal protection violation. Every person has the right to vote with their vote counted as one vote and not have his or her vote diluted or voided out by the counting of an illegal vote. Defendants' handling of the election, as described above and as described in the attached affidavits, establish how rampant and systemic fraud devalued and diluted plaintiffs' civil and political rights. Then we have a conclusion to the same effect. And finally, we have count 5, statutory election law violations. I'm not going to go over the affidavits. They just reiterate the allegations that were incorporated into the lawsuit. Suffice to say that all of the allegations in the lawsuit were substantiated by the 7 sworn affidavits filed in support of this lawsuit. I will include a link to the lawsuit in the pinned comment so you can go read it for yourself, read the affidavits, determine whether or not you think these allegations are sufficiently serious and sufficiently justified, at the very least prima facie. That is to say, is there enough evidence to justify this lawsuit on its face? It may never be able to be proven in a court of law. The affidavits might be full of malarkey, to use someone's expression. Come to your own conclusions. At the very least, now you have a better idea of the facts to do so. And with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
Feed me all night long.
If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. We've got merch. Robert Barnes and I have a locals page. It is called vivabarneslaw.locals.com. You can support us over there if you want. And Robert Barnes and I will be discussing this lawsuit during our next live stream. But more important than any of that, take care of yourselves, check in on friends and family, see that everyone around you is doing well. Don't be afraid to talk about these things with other people in a polite and civil manner, just to show that we are all ultimately humans at the end of the day. And okay, and with that said, now you know your vlog. Peace out.